All rise. The African Court of Justice and Human and People's Rights is now in session. Judge President Wayne Ramwell presiding together with Judge Joy Adeke-Mary and Judge Faith Sibiu. The matter before the court is the situation in Uzuri, the Office of the Prosecution versus the Defense, Ms. Lushomo Ngala. Each team has been allocated 35 minutes of this course time. Mr. President of Mr. President is to you now.
Okay, thank you. So welcome to all counsel. I'd like to first call upon, please, the first prosecutor. First prosecuting counsel.
I request for 1 minute. The first counsel for prosecutor is having network challenges and is trying to log in.
Okay, thank you for informing us. You may proceed. You requested an additional 1 minute just to work out the technical issues? I couldn't quite hear, you see, what was said.
I think the counsel is here now, Mr. President.
Right. So I'd like to invite, please, the first prosecuting counsel.
May it please this honorable court. My name is Sande Sharif, appearing on behalf of the prosecutor with my co-counsel, Nasije Gloria. In 10 minutes, I'll be submitting on the first issue as to whether the charges against Mr. Lushomo Ngala are admissible for this court. In 22 minutes, my co-counsel will address the nature of the crime, the standard of proof, and will proceed to submit on the second and third issues, and then we shall reserve 3 minutes for rebuttal. With your permission, Your Honor, I'll proceed to submit on the first issue.
Yes, please go ahead.
Pursuant to Article 28A of the Malabo Protocol, this court has jurisdiction to hear this matter. In regards to the first issue as to whether the charges against Mr. Lushomo Ngala are admissible before this court, I'll make two head arguments. One, I'll base on the complementarity principle, and secondly, on the sufficient gravity test. Addressing the first count on complementarity principle. Your Honor, complementary principle is established under Article 46H, Clause 1 of the Malabo Protocol, which states that this court has the power to complement national courts and courts of regional economic integration. Your Honor, I would like to persuade this court with a decision on the prosecutor's request for the authorization of an investigation in regards to the situation in Georgia at paragraph 39, which we shall herein refer to as the situation in Georgia. Where it was stated that complementary principle requires an assessment as to whether there are any ongoing proceedings in the national court or in the courts of regional economic integration. Your Honor, basing on the facts at hand in this case, there are no any ongoing investigations in the domestic court. I would like to direct this court to paragraph 28 of the brief facts, where Salima issued an arrest warranty against Mr. Lushomo Ngala, but however, Mr. Lushomo Ngala had already fled to the kingdom of Bukada. Salima still requested that the kingdom of Bukada extradicts Mr. Lushomo Ngala, however, the request was turned down. This means that Salima had the willingness to prosecute the accused, however, they were unable to obtain her. The test of inability of a domestic court to continue with the proceedings is also provided for under Article 46H, Clause 4 of the Malabo Protocol, which gives the court the power to inquire as to whether indeed the state was willing but unable to continue the proceedings. And one of the requirements set in Clause 4 is the inability to obtain the accused. Your Honor, it is the prosecution's submission that indeed we are willing but unable to obtain the accused as provided for in Clause 4 in Article 46H of the Malabo Protocol. Your Honor, having fulfilled the complementarity criteria, the following assessment in regards to admissibility is on sufficient gravity. I would like to persuade this court with the case of prosecutor versus Samoei Ruto in the ICC Pretrial Chamber 2 at paragraph 62, which stated that in assessing sufficient gravity, two criteria must be followed. One is a quantitative criteria, and secondly is a qualitative criteria. I will address the quantitative criteria first. The quantitative criteria is defined in the case of prosecutor versus Abugada in the ICC case of 2010 in Pretrial Chamber 1 at paragraph 31 to mean the number of victims of the war crimes. Your Honor, I would request this court to read with me paragraph 21 of the brief facts. On the last line, it stated that 37 people were killed and 42 were injured. Furthermore, in paragraph 25, the last line, a known number of civilians were also killed. This shows that indeed, when it comes to the number of victims, we have registered very many victims. I would also like to proceed to the qualitative criteria. The qualitative criteria was defined in the case of prosecutor versus Al-Hassan in the Pretrial Chamber 1 in 2009 at paragraph 47 to mean nature, scale, manner, degree of participation of the accused, and the resulting impact of the war crimes. Your Honor, I will address one element up to the last element. The first element is on the scale. Your Honor, in regards to the scale, it is measured on a weight spread. Weight spread was defined in the case of prosecutor versus Omar Hassan in the ICC Pretrial Chamber 1 in 2009 at paragraph 81 to be measured on a large scale, in that the number of victims must be on a large scale. In regards to the facts at hand, indeed the scale is a weight spread because we have lost 37 people and 42 were injured, and even including other unknown number of civilians who were killed, in reference to the facts paragraph 25 and 26, the last lines. All of them show that indeed the spread was on a large scale. This means that the prosecution has already proved to this court on a reasonable ground that the scale was weight spread. In regards to the nature, Your Honor, nature is connected to the systematic occurrence. Systematic occurrence was defined in the case of prosecutor versus Kadik in the appeals chamber in the ICTY in the judgment of 2004 at paragraph 94 to mean that the attacks occurred in an organized manner, in that there is no probability that the violent acts occurred abruptly or were unplanned. It means that the attacks must have been, or the violence must have been planned, must have happened in a pattern, and there is no random occurrence in regards to the nature, it being systematic. Your Honor, I would request that you read with me paragraph 22 of the brief facts, paragraph 22 of the brief facts from the second lane to the fourth lane, whereby when the Kadibanya Armed Forces were looking for alternatives to foster or to make sure that their military forces are well equipped, the first thing they thought of is approaching Ms. Mongala to inquire whether she has any program that would help them equip their ground forces. Your Honor, Ms. Mongala informed them that indeed she has an Adam eye, which would help them in exactly what they wanted. What does this mean? It means that they had the intention of making sure that their ground forces are well equipped. They went further to look for the means how they can achieve this, and they accessed Ms. Mongala. Their request was accepted. What do we see in paragraph 25, the last line? We see that the result was the death of a known number of civilians. Furthermore, in paragraph 26, the last line, there were also a known number of deaths of civilians. This means that this did not happen suddenly. It was planned and eventually it was achieved. That means that indeed, in regards to the nature, it was systematic. Your Honor, proceeding to the resulting impact. The resulting impact, Your Honor, has gone beyond the victims. It has gone up to the population, because the population has to cope up with the death of 37 people, 42 injuries, and other unknown number of civilians who died. It means that the resulting impact has gone out, has shifted from the civilians and has gone to the population. And in the case of prosecutor versus Omar Hassan in the trial chamber in 2010, it was stated that when the resulting impact shifts or goes beyond the victims to the population, it has already fulfilled sufficient gravity. It is our humble submission as the prosecution that now the impact has shifted from the victims themselves to the population, which has to cope up with the death, injuries, and other unknown number of civilians that have died. it is our humble submission that this court finds that we have proved on a reasonable ground that indeed the resulting impact shifted from the civilians and now onto the population. Your Honor, moving on, the degree of participation of the accused. It's the prosecution's submission that the degree of participation of the accused is a high degree of participation. Your Honor, in regards to the degree of participation of Ms. Lushomongala, one, we shall make this assessment from first her invention of AFROCT, as seen in paragraph 14, line 6, whereby the government was inquiring about the implementation of AFROCT. Your Honor,
Counsel, you're starting to give us requirements. Is there any specific authority that you derive these requirements from?
much obliged, Your Honor. These requirements were stated in the case of Prosecutor versus Al Hassan at paragraph 91, where there was a detailed definition of what a qualitative criteria means, and a number of them, including the degree of participation of the accused, the scale, the manner, were stated in that case, Your Honor. I would like to proceed to the degree of participation of the accused. It is our submission that the degree of participation of the accused was high. First, from the invention of AFRO. When the Kadibonye government approached Ms. Lushomongala as to whether they can implement AFROCT in Kadibonye, Your Honor, Ms. Lushomongala's response was yes. She did not only respond positively, but she further went on to tell the government that there will be an updated version of AFROCT in April 2002, as seen in paragraph 14, the 6th line. This shows that her degree of participation was high. Furthermore, if I also to refer to this quote to the bad target in paragraph 15, in paragraph 19, the 5th and the 6th line, Ms. Lushomongala is the CEO of Asoirama, and the bad target was collecting all the threats identifications into Asoirama. Then Asoirama would send this information to the Kadibonye forces. All this, to sum it up, Your Honor, it shows that her degree of participation was high. In conclusion, Your Honor, it's our humble submission that this court finds that it has jurisdiction to hear this matter, and the charges against Ms. Lushomongala are admissible, having met the qualitative criteria and quantitative, and above all, the complementary principle. It's our submission that these charges are admissible. With that, Your Honor, I would like to call upon my co-counsel to submit on the second and third issue. Much obliged, Your Honor.
Thank you very much for your, sorry.
Counsel, before you go, is it the next floor speaker who's going to classify what kind of what kind of armed conflict we have?
Yes, Your Honor. As I was giving our roadmap, she's the one who's going to give the classification and also is going to address us on the standard of proof. Much obliged, Your Honor.
Okay, and the intent of the accused in committing these crimes?
I beg your pardon, Your Honor.
Who is addressing us on the intent of the accused in committing these crimes?
My co-counsel will address on the intent of the accused when addressing the third issue, Your Honor.
Okay, please.
Okay, thank you for that, Prosecuting Counsel 1. I would like now to call upon Prosecuting Counsel 2 to continue the submission on behalf of the prosecution.
May it please this honorable court. My name is Counsel CJ Gloria, as earlier introduced by my co-counsel, appearing on behalf of the prosecutor, and I'll be classifying the armed conflict at hand and addressing issue 2 and issue 3. With the permission of this honorable court, I would like to proceed and classify the armed conflict at hand. And before classifying the armed conflict at hand, Your Honors, international humanitarian law is a set of rules that seeks for humanitarian reasons to limit the effects of armed conflict. And it protects persons who are not or who are no longer taking part in hostilities. And it lays down the responsibilities of states and non-state armed organizations during an armed conflict. And it is important for this court to note the principles of international humanitarian law. That is the principle of distinction, principle of proportionality, and the principle of precaution. And would request this honorable court to uphold justice. And in classifying the armed conflict at hand, there existed an international armed conflict. And an international armed conflict is defined under Common Article 2 to the 4 Geneva Conventions as a conflict that arises between two or more contracting states. And this position was re-echoed in the case of Prosecutor versus Dusko-Tadic that was decided in the appeals chamber of ICTY in 1999 under paragraph 84. Your Honor, if I may refer this Honorable Court to paragraph 16, line 4 of the moot problem. It is clearly stated therein that the Salima armed forces crossed the border and clashed with the Kindibonyi armed forces for about an hour. And at that point of time, the conflict existed between two states, that is the state of Salima and the state of Kindibonyi, and it amounted to an international armed conflict, Your Honor. Proceeding to addressing the standard of proof, Your Honor, if I may persuade this Honorable Court with the Rome Statute under Article 67, Clause 1, it provides that the standard of proof in a pretrial chamber is on reasonable basis. And this position was re-echoed in the case of Prosecutor versus Caltix Mbarushimana that was decided in the prior chamber of ICC in 2001 under paragraph 39 that in determining the standard of proof, it is on reasonable basis, whether there are substantial grounds to believe that the crimes that the accused is being accused of, he or she committed them. Your Honor, proceeding to addressing issue 2, the prosecutor will submit under 3-head arguments that 1, the confinement was unlawful, and secondly, the attacks were directed at planned protected persons, and thirdly, the attacks were directed towards protected property. To begin with, Your Honor, is that the confinement was unlawful. Your Honor, for it to amount to have been an unlawful confinement, there are 2 elements that must be satisfied, and they are cumulative in nature. And these 2 elements have been set in the case of Prosecutor versus Dario Kodik and Mario Sass that was decided in the appeals chamber of the International Criminal Tribunal for the former Yugoslavia that will thereon be referred to as ICTY in 2004 under paragraph 73, and the case of Prosecutor versus Delalik and others that was decided in the appeals chamber of ICTY in 2001 under paragraph 322, that the first element is when a civilian or civilians have been detained in contravention of Article 42 of the 4th Geneva Convention. And Article 42 of the 4th Geneva Convention provides that the internment or placement of protected persons in an assigned residence may only be ordered if it makes the security of the detaining power absolutely necessary. And for it to be absolutely necessary is only if it poses a threat to security. And in the instant case, it did not pose a threat to security. If I may refer this Honorable Court to paragraph 15, line 2 of the moot problem, the Uzurian residents that were confined were only confined for merely supporting the ULF. And at that point of time, not only were they confined, unlawfully confined in contravention of Article 43, of Article 42, because they did not pose a threat to security, but also the freedom of speech, which is enshrined in Article 19, Clause 1 of the International Covenant on Civil and Political Rights, that everyone shall be entitled to hold their opinions freely without interference. And this was not in the instant case, as it was interference. Hence, the prosecutor submits that the first element is satisfied, as the accused were detained in contravention of Article 42 of the 4th Geneva Convention. And proceeding to the second element is that when a civilian or civilians have been detained in contravention of Article 43 of the 4th Geneva Convention. And Article 43 of the 4th Geneva Convention provides the procedural safeguards that any protected person who has been interned or has been assigned to a resident shall be entitled to a reconsideration as soon as possible by an appropriate court or an administrative board. And yes, in the instant case, pursuant to paragraph 15, line 10 of the moot problem, the procedural safeguards were met. However, these two elements are cumulative, and although the procedural safeguards were met, the confinement from the inception was unlawful as the Usurian residents did not pose a threat to security. Therefore, the prosecutor submits that the Usurian residents were detained in contravention of Article 42 and the Article 43 of the Fourth Geneva Convention. Hence, the offense of unlawful confinement was committed in Usuri pursuant to Article 28D of the Malabo Protocol. Proceeding to addressing the second.
So before you proceed, if Ms. Shomongala and her IA were eliminated from the equation, do you still think these people, the crime of unlawful confinement would still have been committed?
No, no, Your Honor. If I may refer this honorable court to paragraph 11
So
of the
your position is no?
My position is, if she had not provided this afro, then the confinement would not have happened. And if I may directly refer this honorable court to paragraph 11 of the moot problem, it is clearly indicated therein that the detention facility, the Kindibonyi armed government had run short of the detention facilities. And as Ms. Shomongala provided the afro, it aided the commission of the offense of unlawful confinement, Your Honor. Proceeding to addressing the second head of argument, the attacks were directed at
sorry to interrupt and cut you short. You said her provision of the Adolf software actually just aided the betterment of the commission of this war crime, but removing her from the equation should still be, the confinement would still have occurred.
No, Your Honor.
Okay, proceed.
Yes, Your Honor. Addressing the second head of argument that the attacks were directed at plan protected persons, Your Honor. Civilians shall not be an object of attack. This is pursuant to Article 51, Clause 2 of Additional Protocol 1 to the Geneva Conventions. And civilians shall enjoy such protection unless they are taking part in direct participation in hostilities under Article 51, Clause 3 of Additional Protocol 1 to the Geneva Conventions. And this was re-echoed in the case of Prosecutor versus Caltex Mbrashumana that was decided in the pretrial chamber 1 of ICC in 2011 under paragraph 148. And also the court further noted that the protected status of the civilians shall not be lost if the civilians engage in violent acts or pick up weapons or other means to commit violence in situations of self-defense. And if I may refer this honorable court to paragraph 21, line 6 of the moot problem, it states that the gunners opened fire at the civilians and the civilians picked up stones and threw them at the armored vehicles, believing that they were the target. And in that point of time, it is first the bad target that released the fire at the building. That's when the civilians picked up the stones and threw them at the armored vehicle, thinking that they were the target. And at that point of time, they were acting in self-defense and they were not taking part in direct hostilities. And Your Honor,
Counsel, could I pose a question, please?
Yes, Your Honor.
So I want to ask, by the actions of the civilians in that particular context, did they not potentially lose their protective status because of the throwing of stones?
No, Your Honor. And to substantiate on this, the ICRC interpretative guidance on the notion of direct participation in hostilities under international humanitarian law has set 3 cumulative criteria that must be met. And the first, for one to amount to have been directly participating in hostilities. And the first criteria is the act is specifically likely to adversely affect the military operations. And in the instant case, if I may refer this honorable court to paragraph 21, line 8, it is only Lieutenant Kamu who was hit on the head by a stone and he required medical attention. However, these stones did not damage the armored vehicles. Hence, it did not adversely affect the military objectives. And proceeding to the second element, it provides that the causation, it provides for causation. And in this instant case, the test of causation fails because there was no harm that adversely affected the military operations. And proceeding to the last element, that is the belligerent nexus. The belligerent nexus provides that when the civilians conduct themselves in a way of supporting one party to the conflict at the expense of the other party, then at that point, the belligerent nexus is met. However, the belligerent nexus is different when the civilians are conducting acts of self-defense. And if I may refer this Honorable Court to page 61 of the earlier cited ICRC's interpretive guidance, it is stated therein that the belligerent nexus is not met where the use of necessary and proportionate force is in self-defense and cannot be regarded as a direct participation in hostilities. Therefore, it is the submission of the prosecutor that the civilians did not take indirect participation in hostilities and did not lose their protection. Therefore, these attacks were directed at protected persons under Article 4 of the 4th Geneva Convention. And these attacks, yes, Your Honor.
You're saying all this was done in self-defense. So you're implying that the government of Kedibonyi is the one that attacked first, forcing the civilians to throw stones at them?
Yes, Your Honor.
Refer us to the fact sheet, please.
Under paragraph 21, line 6 of the moot problem, Your Honor. If I may proceed to address on that issue, is that the principles of international humanitarian law were violated at that point of time. That is the principle of distinction, as the bad target was not able to distinguish between civilians and the military objectives and ended up injuring the civilians. Hence, that principle was violated. And the principle of proportionality was violated in that point of time. And this principle of proportionality is provided for under Article 51, Clause 5, Paragraph B of Additional Protocol 1 to the Geneva Conventions, that it is prohibited where it is expected to cause incidental loss of civilian life, injury to civilians, and damage of property, or a combination of both, which will be excessive in relation to the concrete and direct military advantage. And in this instant case, these attacks resulted indeed to the loss of civilians. That is 37 civilians and 42 were injured. And also the injury was excessive to the military advantage. Therefore, the principle of proportionality was violated, and the principle of precaution, which is provided for under Article 58, Paragraph B of the Additional Protocol to the Geneva Conventions was violated, which provides that parties to a conflict should at all times be able to avoid locating military objectives in densely populated areas. And in this instant case, there were 250 civilians and there was only one ULF soldier. Therefore, they violated that principle of precaution. Therefore, the prosecutor submits that the attacks were directed at planned protected persons and the offense of attacks against planned protected persons was committed. Yes, Your Honor.
I think your explanation is more of the principle of distinction, given the fact that you're saying there were 250 civilians and yet one military person. I think you're referring to the principle of distinction. So could you please address us on the principle of precaution that you just stated?
Yes, Your Honor. The principle of precaution provides that in an armed conflict, the parties to an armed conflict should take all feasible measures to prevent the commission of incidental loss, excessive loss, and this is provided for under Rule 19 of Customary International Humanitarian Law, and also under Article 58, Paragraph B of the Malabo of Additional Protocol 1 to the Geneva Conventions, and this was violated in this instant case, Your Honor. Proceeding to addressing that last head argument, the attacks were directed at protected property, Your Honor. And Your Honor, there are 5 elements that must be satisfied and these were provided in the case of prosecutor versus Dario Kodik and Mario Sass. That 1, the attack resulted in damage. And if I may refer this honorable court to paragraph 25 line 6 and paragraph 26 line 8, the civilian properties, that is the church and the sanctorium, were damaged in that instant case. Therefore, the attack resulted to damage of civilian property, and that element is satisfied. The second element is the civilian character of the objects ought to have been known or should have been known. If I may, yes, Your Honor.
Sorry to interject. The fact case actually tells us that this church and sanatorium were actually being used for military objectives. What do you have to say about that?
Your Honor, it was not being used for military objectives. It was only being used for religious purposes, as it is indicated that the burial of Major Faustino was conducted, and also there was the presence of the priest and the acolytes, and it is not stated anywhere that it was used for military purposes. Therefore, it was a protected property under Article 53.
Counsel, if I may refer you to fact sheet paragraph 24. Line 6, it clearly says that in abandoned and depleted sanatorium north of Jajabulani, Adam discovered important ULF command centers and mutation stockpiles. So if these are command centers, that means there's military activity going on. So could you please address us on that?
Yes, Your Honor, that is under paragraph 24, and it is independent from paragraph 25, and it is not clearly stated or directly stated that it is the St. Eligas Church. And Your Honor, the civilian status of a church, although it is not being used, does not take away its civilian status, Your Honor. It is still a civilian property. Proceeding to addressing the third element, the attacks were willfully directed at civilian objectives, that is the church and the sanctorium, pursuant paragraph 26 line 8 and paragraph 25 line 6, and there was a direct nexus between the attack and an armed conflict. And lastly, the accused is individually criminally responsible for this attack. If I may refer this honorable court, paragraph 27. Yes, Your Honor.
Still sorry to interrupt. I'm just not satisfied with your answer because I believe the facts are stated clearly. Still paragraph 24. Adam went operationally on that September 9th, 2022 during the military operation to Uzuri. Adam spent several weeks gathering information on small groups of ULF fighters, and according to that data, those groups were frequently meeting near small abandoned churches and chapels and so forth, which takes me back to, do you say that these churches and sanatoriums still did not have military activity going on?
Yes, Your Honor. In particular, the St. Eligas Church, Your Honor. It is not indicated in the facts anywhere. We are only shown that it was used for religious purposes, Your Honor. Proceeding on substantiating the last element, under paragraph 27, line 7 of the moot problem, when Ms. Lisho Mangala was informed that the patching would not be sufficient, she further directed the software engineers to continue to patch the software. This clearly indicated that Ms. Lisho Mangala was aware that it would not be able to distinguish between a civilian object and a military objective, and continued to provide it to be implemented. Therefore, she is individually criminally responsible for that war crime. Proceeding to addressing the last issue, Ms. Lisho Mangala is individually criminally responsible for war crimes committed in Uzuri, pursuant to Article 28, pursuant to Article 46B of the Malabo Protocol. And in substantiating on this, the defense will submit that 1, Ms. Lisho Mangala was an accomplice to the commission of the offense of unlawful confinement, and secondly, Ms. Lisho Mangala aided the commission of the offense of attacks against plant protected persons, and thirdly, she is liable for the commission of the attacks against protected property. To begin with, Your Honor, is that Ms. Lisho Mangala is an accomplice to the commission of the offense of unlawful confinement. Under paragraph 12, line 2, it is clearly indicated that the Kindimboni Armed Forces had run shortage of the detention facilities. And if Ms. Tisho Mangala had not provided this AFROP, they will not be able to confine the Uzurian residents. Therefore, she is an accomplice in the commission of that offense, and she had the intent that the Uzurian residents be confined. I request this Honorable Court to kindly add me 3 minutes to conclude on this issue. And proceeding to addressing this issue, Ms. Tisho Mangala is also under paragraph 6, line 1 of the mood problem. She is the CEO of Asairoma and the founder of Asairoma, which specializes in ICT, AI, and social media. And under paragraph 14.
Council, sorry to interrupt. I'd be happy to grant you 1.5 minutes in light of the interjections. And I hope that you'll be able to summarize instead of the 3 minutes in the 1.5 minutes.
Okay, Your Honor. Ms. Tisho Mangala aided the commission of the offense of attacks directed towards protected persons because she was able to give an assistance. This was provided under the case of prosecutor versus Jean Paul Akayesu that was decided in the trial chamber 1 of ICTR in 1998 under paragraph 484. Therefore, as she gave an assistance, and this was able to help the Kindimboni Armed Forces to achieve their motive of targeting the ULF soldier as indicated in paragraph 27, line 6 of the mood problem, she aided the commission of the offense of attacks directed towards protected persons. And thirdly, lastly, Ms. Tisho Mangala is liable for the commission of the offense of attacks directed towards protected property. In the case of prosecutor versus Jermaine Katanga, the first element is the actus rea. And Ms. Tisho Mangala had the actus rea pursuant to paragraph 27, line 7, where she ordered the software engineers to prevent the Adam from making, where she was informed that Adam struggled to make decisions at all circumstances, but she continued to provide Adam and it was implemented. And the mens rea is provided for under paragraph 27, line 2, where the software engineers informed her that despite the patching, it would not be sufficient. Adam will not be able to distinguish at all circumstances, but she ignored that and they went ahead to implement the Adam I. Therefore, the mens rea element is met and the actus rea, and the attacks were directed at protected property. We request this Honorable Court to respectfully find that there are reasonable grounds to believe that attacks of unlawful confinement, attacks against protected property, and attacks against protected persons were committed in Uzuri pursuant to Article 46B of the Malabo Protocol, and Ms. Tisho Mangala is individually criminally responsible. We so beg to submit, Your Honor.
Thank you very much to the prosecution for your submission. I'd now like to call upon the first defense counsel to state their case. Is the first defense counsel able to present their part of the defense?
Thank you, Mr. President. Your Excellencies, may it please the Honorable Court. Before you is Dan Sondunda, the lead agent for the defense. In the 35 minutes allocated to us, I'll use the first 15 minutes to substantiate with respect to the first issue and the third issue. The remaining 20 minutes, Mr. Bitamputia, my co-counsel, will use the first 15 minutes to substantiate with respect to issue 2 and also give the prayers of the court. We reserve our 5 minutes for rebuttals. If that clearly explains the nature of our submissions, we beg to proceed.
Yes, please go ahead, Counsel.
And to the first issue on whether the case of Ms. Lusho Mongala against the case against Ms. Lusho Mongala of war crimes is admissible before the court. It is the submission and the stand of the defense that the case against Ms. Lusho Mongala is not admissible. In advancing our point, we shall rely on one argument, that is the sufficiency gravity test has not been met. Your Excellencies, the sufficient gravity test, as it has been clearly set out in the Malabo Protocol, as in particular,
I think there might be some technical issue at hand.
I think the defense one has muted himself and switched off the video.
Sorry, Your Excellency, I beg to proceed. I was having an issue.
Yes,
Can
of
you hear
course.
me?
Yes,
Can you
I
hear me?
can. Yes, we can hear you.
Thank you. If I may be allowed to proceed.
Yes, of course.
It is the stand of the defense that the sufficiency gravity test has not been met. Your Excellencies, as clearly provided for under the Malabo Protocol, particularly Article 46H 2D, that a case will not be inadmissible, that a case will be inadmissible in any event that the sufficiency gravity test has not been met. Your Excellency, sufficient gravity test was further provided for in the case of prosecutor versus Charles Lubanga, whereby the court clearly states that even if a matter falls within the jurisdiction of the court, it will not be admissible before the court if the sufficient gravity test has not been met. Your Excellency, while looking at the sufficient gravity test, it is keen not only to look at the quantitative factors, but rather the qualitative factors also have to come into play. Your Excellency, I rely on the case of prosecutor versus Al-Hassan. This is a decision that was made in 2020 in the International Criminal Court Appeals Chamber. In that case, Your Excellencies, it was clearly stated that while establishing the sufficiency gravity test, numbers are not only supposed to be looked at, but rather the case should be determined on a fact-to-fact basis, on the basis of the facts provided. Your Excellencies, it is the submission of the defense that the sufficient gravity test has not been met because as it will be substantiated further by my co-counsel, indeed, there are no war crimes that have taken place in this case, Your Excellencies.
Have you addressed your mind to the case of Katanga? It clearly states that, if I may paraphrase, cross-killing of civilians is enough to actually prove sufficient gravity. So whether it is 3 civilians or SOT or 20, or that would amount to sufficient gravity. What do you have to say about that?
Your Excellency, as it will be substantiated further by my co-counsel, the number of people that were killed in the present case were killed, they had actually lost their civilian status. They were killed, the killings that occurred in the present case, they were killed in pursuit of a clear military target, Your Excellency. That is why, as it will be substantiated by my co-counsel, indeed, there was no killings of protected civilians in the present case.
Okay, proceed.
Your Excellencies, as I have asked this honorable court to look at the clear fact patterns, the clear facts that are provided for in this case, the killings that took place in this case, Your Excellencies, they actually occurred. The civilians that were killed were killed actually in a situation whereby they had lost their status, and that will be substantiated further by my co-counsel. Your Excellency, having been able to persuade this honorable court that the sufficient gravity test has not actually been proved because there were no war crimes that have been committed in the present case, I would love to move to my second issue on whether there are substantial grounds to believe that Ms. Lusho Mongala is individually responsible for the war crimes that have been committed. Your Excellencies, with regard to individual criminal responsibility, the defense is not oblivious of the provisions of Article 46B of the Malabo Protocol that clearly provides that anyone who commits crimes that are stated under the statute shall be individually responsible. However, Your Excellency, it is the stand of the defense that Ms. Lusho Mongala has not committed the crimes of the war crimes that have been that are provided for in the statute. Your Excellency, in advancing our provision, we shall rely further on the Malabo Protocol, specifically Article 28N, that clearly provides for the different and the various modes of responsibility that can be that can accrue to an individual. And Your Excellency, it is the stand of the defense that in no way has Ms. Lusho Mongala participated in aiding and abetting commission of war crimes in the present case. Your Excellencies, with regards to Ms. Lusho Mongala not being in a position of aiding and abetting the commissions of the crime, the defense would like to clearly provide for two clear tests that have been provided in order to determine that one has aided or abetted in the commission of the crime. And those two elements were clearly provided for in the ICTY case of prosecutor versus Antoine Frunzija. Your Excellency, the two elements are both the subjective element and also the objective element. Your Excellency, addressing this court to the objective element, the objective element of the commission of the crime of commission of aiding and abetting, Your Excellency, with respect to aiding and abetting, one is considered to have met to have satisfied the objective element of aiding and abetting by providing a substantial assistance to the commission of a crime. And with respect to the subjective element, one requires to have the knowledge or the intent that their actions are going to be in a position of facilitating the commission of a crime. Your Excellency, I would love to refer this honorable court to the fact matrix that we have been provided in order to establish that Ms. Lusho Mongala did not have any intent to commit war crimes. Your Excellency, as clearly provided in fact paragraph number 6, Ms. Lusho Mongala is a citizen who is committed to making the world to be a better place. And we clearly see, even as provided for in fact paragraph number 7, that she's using her AI knowledge. She's using the knowledge that she has, her prowess in AI, even to facilitate better security measures and also to be able to control traffic. That one clearly shows that she has no intent in commissions of a crime. Your Excellency, the AfroOpt AI software is the one that is being linked with unlawful aiding and abetting the commission of unlawful confinement. Your Excellency, it is clear, as it is clearly provided for in the fact paragraph pattern, after the government of Kedibonye realizes that their detaining facilities had actually could not actually have the capacity of detaining more people, they tried to find solutions, and they approached Ms. Lusho Mongala. But however, Your Excellency, as clearly provided for, and to clearly show this honorable court that Ms. Lusho Mongala did not have an intent to commit the crimes or the crime of unlawful confinement, in the meeting, Your Excellency, as clearly provided for in the factual matrix, we are told that in the meeting, Ms. Lusho Mongala was not clearly told that the AfroOps AI was going to be used to be able to facilitate confinement of people. In the meeting that they had with the Kedibonye government, Ms. Mongala was actually inquired if she could have any software that could be able to enhance security. And that is why she provided for this AfroOps AI. Your Excellency, I would love also to guide
Council.
Council, sorry, I let my co-judge go first.
Okay, if I may refer you to paragraph 22 of the fact sheet, specifically line 8, 9, and 10. It says, during the meeting, Ms. Mongala assured the Konibonye representatives that ADOM, with some additional software changes, could be fully operational for the purpose. What do you have to say about that? Because your argument is that she was not aware, and yet she was actually aiding the Kodibonye representatives and letting them know that actually I have better changes to help to aid what you're doing.
Thank you, Your Excellency. With respect to that, Your Excellency, the defense would actually submit that in a way of seeking for better weapons, the Kedibonye government actually went and approached Ms. Mongala with respect to AI software. And we realized that, as clearly provided for in the factual matrix, the AI software by the name ADOM was a software that was designed even to be in a position to uphold the international humanitarian laws of such as the law of the principle of distinction. And that is why we are clearly provided for in the factual matrix that the software was programmed to collect information for 15 days. That clearly shows that there was that precaution that this software was clearly intending to ensure that only the military targets, and in this case, the military target, that is the ULF fighters, were being able to be targeted by this software, Your Excellency. Therefore,
but it failed. Council, but it failed. Civilians got injured. It failed. That's why the prosecution has brought Ms. Mongala here before this court.
Thank you, Your Excellency. With respect to that, it is the submission of the defense that Ms. Mongala actually took all the necessary precautions to be able to ensure that the ADOM AI software was working. That is why, as it is clearly provided for in the factual matrix, Ms. Mongala is telling her software, the software engineers, that continue monitoring this software to ensure that it functions properly. And further, Your Excellency, I would love to clearly state that Ms. Mongala did her part of the bargain, because she had clearly even informed the government of Kadibonye that there could be chances that the system could fail. Therefore, she's not supposed to be held individually liable, because all the information she had given, the threats, the risk of this ADOM AI, she had actually revealed them to the Kedibonye government. Therefore, the people should be blamed in this present case is the military system, is the government of the state of Kedibonye, but not Ms. Mongala. And further, Your Excellency,
Council, if I may, so is it your position that based on her attendance at meetings, we cannot infer from the circumstances that she was aware of the intent or the malintent to commit a crime?
Yes, Your Excellency, it is our stand as the defense that she did not have the intent at all to commit these crimes, because of even the fact that even if I could substantiate further, pursuant to fact paragraph number 18, actually the Republic of Kedibonye, on realizing that many civilians were killed, they were looking for a more sophisticated technology that could distinguish between the civilians and the military objects. That is why they went to Ms. Mongala, who was able to come up with the bad target AI. The major objective of that was to distinguish between the civilians and the military target, meaning that she was clearly in her place trying to uphold all the international humanitarian law principles, Your Excellency. Your Excellency, I would ask for additional 1 minute just to wrap up my argument.
Yes, absolutely. So for the sake of being equal between the prosecution and defense, I'll grant you exactly what you've asked for.
Thank you, Your Excellency. And Your Excellency, in my last limb of argument to substantiate that Ms. Lusho Mongala did not have the intent to commit the crimes herein, Your Excellency, I'll refer this honorable court further again to fact paragraph number 19, whereby we are clearly told that after the bad target AI software was applied, Your Excellency, this system was effective, and as a result of it was realized that the number of civilians that had been killed and injured after the coming to force of the bad AI software was the civilians were fewer, Your Excellency, and in that regard, Ms. Lusho Mongala should not be held individually criminally responsible for aiding and abetting, because she lacked the intent and she was able to she was able to apply precautions in order to prevent the commission of the crimes. I would love to cede the floor to my co-counsel.
Thank you very much for the first defense counsel. I'd now like to invite the second defense counsel to add to the defense.
Your Excellencies, may I ask whether I can be seen?
I cannot see you, but I can hear you. If that helps.
I don't know why, but my video is turned on, but I can't be seen.
Sorry, your voice is very far, and maybe you could switch off the video and then switch it on, and then you need to come very close to the microphone, whatever you're using.
Is it better? Can I be heard clearly?
You can be heard, but it's not as loud as we would hope for. Is there any way to amplify your volume, if possible?
Okay, so what about right now?
I can just about make it out, but I have to check with my co-judges. Are you able to hear?
I can hear, but it's low.
Yeah, same for me.
Yeah.
Okay, so apologies for that. What about right now? I think I've tried to fix it a bit.
Yeah, I think a little bit better now. Perhaps you might have to shout a little.
Okay, okay. So is this better? Can I submit like this?
Yeah, I mean, I'm happy with that, as long as my co-judges are also happy with that.
Yeah, sure.
Okay, and just to ask, can I still be seen? Since I don't know why, but my video is
No,
on,
you can't be seen. I think the whole problem is with your network. So unless maybe you want to reconnect, that possibly would fix your video. It cannot be seen. It's because of the network issue.
Okay, then I apologize, but can I leave the meeting, then I come back kindly so that I can fix this issue?
I think that will be fine.
Okay, thank you. Your Excellencies, I hope I can be heard quite well right now, and I hope that my technological issues will not be used in any way against us.
Thank you very much. We can hear and see you now. And just to reassure you, of course, any technical issues will not, count against you as part of this process.
Okay, thank you so much. Then perhaps I can begin. Okay.
Yes, you may proceed. Thank you.
Thank you so much. Your Excellencies, may it please the court, my name is Tabitha Mbuthia, counsel appearing on behalf of the defense in this case, prosecutor versus Lusho Mongala. In the 15 minutes that have been accorded unto me by this honorable court, I shall be submitting on issue number 2 as to whether there are any substantial grounds to believe that the following war crimes pursuant to Article 28D of the Malabo Protocol have been committed in Uzuri. Your Excellencies, it is a position of the defense that indeed these war crimes have not been committed in Uzuri, and these are the war crimes of unlawful confinement, attacks against land protected persons, and attacks against property. Your Excellencies, if that clearly shows the intention of my submissions, I beg to proceed.
Yes, you may proceed. Do you also plan, if I may ask, to deal with the classification of the armed conflict?
Your Excellencies, we shall not be indulging in the classification of the conflict, since we do agree with the prosecution that this does amount to an international armed conflict, and therefore do not see the need to substantiate on the same. If that is okay, Your Excellency, if I may proceed to the elements of the crimes.
Yes,
Your
absolutely.
Excellencies, thank you so much, Mr. President. Your Excellencies, the first submission of the defense is as to unlawful confinement. Your Excellencies, the elements of this war crime has been substantiated in Article 8, subarticle 2A of the Rome Statute, and it has given the elements therein to include that, first of all, the perpetrator confined or continues to confine one or more persons to a certain location, and that secondly, such persons are protected persons, and that thirdly, the perpetrator was aware of this protected person's status. Your Excellencies, therefore, to shed more light as to who protected persons are, Article 4 of the Geneva Conventions provides that protected persons are those people who are in the hands of an occupying power of which they are not nationals, which is in the current case the Uzuri citizens who are under the power of the Kedibonye forces. Your Excellencies, therefore, the elements of this war crime have to be necessitated by threats against security. This is by dint of Article 78 of the 4th Geneva Convention. Your Excellencies, therefore, the state has to be necessitated by threats against its own security, and also it has to be able to abide by certain procedural issues, such as, first of all, that it must ensure that the internees are able to revise their case to a court that is impartial and independent. This is by dint of Article 43 of the 4th Geneva Convention, and that secondly, these internees must be able to be purchase certain things such as foodstuffs. They are able to get medical care, and that they're able to engage in recreational activities. Therefore, Your Excellencies, in the current case, we can clearly see, as per paragraph 8, that there has been a widespread upheaval in Uzuri. Moreover, there have been sit-ins, roads have been blocked, and stones and other projectiles have been thrown against the police officers in Uzuri to an extent where they are unable to contain the matter and require the assistance of the Kedibonye armed forces, Your Excellencies. In fact, it has gone to a point where social media is being used to coordinate and organize these armed protests that are of a violent nature. Your Excellencies, therefore, that means that these violent protests are in fact or rather they are a threat against the security in Uzuri, and therefore the Kedibonya government has seen upon itself to confine these civilians so as to ensure that security is maintained. Your Excellencies, in fact, they have gone ahead to ensure that they're doing their due diligence by ensuring that these civilians who have been interned are able to review their cases in the administrative district courts that can be appealed up until the Supreme Court in Uzuri, and this is done every 3 months, Your Excellencies. And they have also be able to ensure that these civilians are able to access foodstuffs, that these people are also able to access hospital care, and that they can even engage in recreational activities. Therefore, Your Excellencies, this unlawful confinement war crime has not occurred in Uzuri by pursuant to it being legal in accordance with the laws that I have given in this current case. Your Excellencies, the second.
Counsel,
Yes, Your Excellency.
just before you proceed, the prosecution gave us a whole argument on the confinement, the war crime of unlawful confinement being based on the IEA that was created by your client, Ms. Nshomongala, and that is why they brought her before this court. But your argument is based on defending the Kedibonye government and what good they have done for the people. I'm confused. Is your client Ms. Nshomongala or the Kedibonye government? Could you please relate your defense to your client rather than to the government?
Thank you, Your Excellency, and I am much obliged. The defense position on this is that the perpetrator in this case, who has been prosecuted, is indeed Ms. Nshomongala. And indeed, she has been accused falsely as being an aider and abetter of these crimes by usage of the AFROPT technology that has been used to confine the civilians. Your Excellency, that is the position of the defense. However, then we are also arguing that this war crime has not taken place by virtue of it being legal in every aspect. If I may proceed to the second argument, kindly. Your Excellency, thank you so much, Your Excellency.
Counsel,
Yes.
before you proceed, you keep on saying civilians. So does it mean you're in agreement with the prosecution that they are civilians, the victims of Old Town Mombasa?
Your Excellencies, in fact, they amount to protected persons, and that is why when I stated the elements of this crime, these people have to amount to protected persons, and it is true that they are. However, the elements have to be situated, or rather they have to be satisfied in its entirety, because they are mutually inclusive. And Your Excellencies, therefore, that is why the defense is arguing that all the legal requirements that are expected from confinement have indeed been satisfied in this case.
Noted,
Your Excellency,
noted,
if I may.
Counsel.
Thank you so much, Your Excellency. If I may proceed to the second argument, Your Excellencies, and that is on the intentional attacks against planned protected persons. Your Excellencies, the elements of this war crime have been also situated in the in Article 8, Subarticle 2B of the Rome Statute, and this is that, first of all, that the perpetrator has directed an attack, and that secondly, the attack is against a civilian population that has not taken part in direct hostilities, and that thirdly, the perpetrator intended that the object of attack would be these civilians. Your Excellency, however, in the current however, the defense also submits that these are not civilians because they have lost that status. And this is by dint of Article 28B, Subarticle 1E of the Malabo Protocol, that provides that civilians lose protection against attacks if and for such a time that they take part in hostilities. And it continues to provide that these are actions that support a belligerent party by directly harming its enemy, either by causing harm or inflicting death. And to shed more light on the same, Your Excellencies, in the case of Prosecutor versus Delalich, the court held that these activities must involve material direct harm against the adversary. And Article 49 of the Additional Protocol 1 also provides that an attack is any act of violence against an adversary, whether in offense or in defense. Your Excellencies, therefore, in pursuit of the same, in paragraph 21, we can clearly see that Lieutenant Kamau Zongo has his own armored vehicles as well as his militants, and they try to ensure that the civilians who have blocked the roads have to depart from those roads in a peaceful manner. Your Excellencies, therefore, the armored vehicles also are able to see that there is a militant amongst, or rather, in fact, behind the civilians, and they attack that person, that ULF soldier who is actually carrying an RPG. However, due to the attack that is made against this militant, the civilians open fire by attacking the militants by throwing stones, and in fact it leads to the injury of this Lieutenant Zongo Kamau, who is of a very high stature in the military activities and in their forces, Your Excellencies. Therefore, this shows that these civilians have actually gone ahead to attack and take part in hostilities by attacking the armored vehicles as well as lieutenant who is injured, and by virtue of that they have lost the civilian protection. By dint of that, therefore, by losing that civilian protection.
Council, if I may just pose a question. So what is actually the direct harm that was caused by the civilians to the military personnel? What is the precise nature?
Thank you so much, Your Excellency, for your question. And just as the defense had brought up, that an attack is any act of violence that is against an adversary, whether in defense or in offense. Your Excellencies, therefore, these civilians were acting as defense by attacking the militants, the Kedibonye armed militants, and therefore by doing so, they had lost their civilian protection. And by the Kedibonye armed forces opening fire against the civilians, they had actually acted within their military mandate, Your Excellency.
And so,
yes, Your Excellency.
Just at the end of your submission, your statement still under paragraph 21, the second last line and last, they opened fire. Do you think they upheld the principle of proportionality? Because if we have the civilians throwing stones, and then what the response to the throwing of the stones is open fire, do you think that that is proportional, stones and heavy weaponry? Do you think the principle of proportionality was being upheld in this situation in relation to paragraph 21?
Thank you, Excellency, for that question. And I will refer to the meaning of the principle of proportionality by dint of Rule 14 of the customary international humanitarian laws, which means that this is a military advantage that should be proportionate to the collateral damage to civilians. Your Excellencies, therefore, the defense actually gives its submission based on the fact that these civilians had been given instructions by the ULF fighters to actually to block the roads, Your Excellencies, and by dint of that, they were acting as in the directives of the ULF, and in fact, when they opened attack, yes.
What is being questioned here is not who was giving directions. My question is it proportional to open heavy weaponry fire on civilians who are throwing stones? If someone slapped you today and you shot them in the head, would that be proportional force?
Okay, thank you so much for further direction. And the defense will then give its answer by stating that it is proportionate based on the fact that these civilians had lost all protection, and proportionality is based on the protection of civilians. So by dint of losing this civilian protection, it was totally proportionate, Your Excellency. If that is sufficient, I may proceed to the third limb of argument on attacks against protected property. Your Excellency, this is also based on Article 8, Subarticle 2C of the Rome Statute that gives the elements of attacks against protected property, and it provides that the perpetrator must have directed an attack and that this attack must have been against protected property, and that the perpetrator was aware of this status of protected property. However, Your Excellencies, the defense also, Your Excellencies, I beg for an additional 1 minute kindly to just wrap up my arguments.
Yes, I would be happy for you to have some additional time.
Thank you so much, Mr. President, for your indulgence. And to just wrap up on the defense's arguments on attacks against protected property, Your Excellencies, in additional protocol 1,
I think she's gone off.
Yes.
Okay. I mean, she's exited the room.
Yeah, I think due to her network. I think her network just pulled out.
Okay.
Yeah.
Yes, it's best to be patient.
Your Excellencies, I beg for your forgiveness for that. I humbly apologize for that internet interruption. And if I may continue with the 1 minute to just wrap up my arguments, kindly.
Yes, yes, please, you can go ahead.
Thank you so much, Your Excellency, for your kindness. And Your Excellency, therefore, as I was submitting on additional protocol 1 of the Geneva Conventions, specifically Article 52, Subarticle 3, provides that if a civilian object is used in such a manner as to make an effective contribution to the enemy's military action, and its destruction actually offers a definite military advantage, then it will qualify as a military objective. Your Excellencies, on the fact matrix, as per paragraph 24 up until paragraph 26, it is stated that St. Eligius Church was actually a military objective due to its being used as a military, as a ULF command center, as a munition stockpile place, and as well as the Mountain View Sanatorium that was also used in the same vein as a military objective. And therefore, by virtue of this protected property being being military objectives, they had lost all kinds of protection, and the attacks that had been brought against them was therefore in the case of it was therefore legitimate due to military necessity. The Excellencies, therefore, the prayers of the defense is that first of all, that the matters that have brought before this court are not admissible, and that secondly, the war crimes that have been stated have not actually occurred, and these are the war crimes of unlawful confinement, attacks against protected persons, and attacks against property. And that thirdly, and most importantly, is that Ms. Lushomongala cannot be held legally liable for all the war crimes that have been committed. Therefore, in that matter, Your Excellencies, the defense begs to rest its case. Thank you, Your Excellencies.
Thank you, Counsel, for your submission. Is it now to proceed on the basis of the prosecution's right of rebuttal?
Yes, the prosecution is now to do rebuttals.
Okay, so I'd like to now call upon the prosecution, if you'd like to make a rebuttal.
Yes, Your Honors. The defense agreed with the prosecution that there is two criteria that must be followed. That is the qualitative criteria and the quantitative criteria for sufficient gravity to be met. However, the defense only addressed the quantitative and did not address the qualitative. So it can be inferred that they have agreed with the prosecution. And secondly, they stated that quantity does not matter. However, in the case of Abugada, prosecutor versus Abugada, the court found that 12 deaths and further attempt to kill 8 amounted sufficient gravity. And in this instant case, pursuant to paragraph 27, line 10 of the moot problem, the death was 37 and 42 were injured. So the prosecutor submits that the sufficient gravity was met. And the defense alleged that the principle of distinction was observed. However, it is the submission of the prosecution that this principle was not observed. If I may refer this honorable court, paragraph 27, line 10, the bad target was not able to distinguish between the civilians and the combatants. Hence, the principle of distinction was not met. And in the report, of special report on extrajudicial summary or arbitrary execution under paragraph 13, Christ of the Hymn stated that the use of weapons which cannot reliably distinguish between combatants and civilians is prohibited. And in this case, it will not reliably distinguish, as it was stated in paragraph 18, line 14, that it will not be able to distinguish where the crowd was more than 50. Hence, it is that attack is prohibited, Your Honor. And lastly, the confined were not suspected of taking part in hostilities, as I had earlier addressed this honorable court on that, as the defense submits. The confined under paragraph 15, line 2, were only merely supporting the ULF. Hence, the confinement was unlawful, Your Honor. And lastly, Ms. Lisho Mangala had the intent to commit these offenses. If I may refer this honorable court to paragraph 22, line 1 of the moot problem, as the Kindimbonyi Armed Forces were looking for alternatives to support their operations in Uzuri, Ms. Lisho Mangala informed the Kindimbonyi Armed Forces during secret talks that Asaroma had developed Adam AI that was a self-testing, and it would be able to help in this instance. Therefore, her intent is indicated under paragraph 22 and line 1 of the moot problem. We so beg to submit, Your Honor.
Thank you to the prosecution for your rebuttal. I would now like to invite the defense for their rebuttal.
Thank you, Your Excellency, for this opportunity for the rebuttal. With respect to the protest, Your Excellencies, it is still the submission of the defense that it was at the protest that took place in Uzuri were a direct threat to security, and that is the reason why the Republic of Kedibonye resorted to actually arresting and confining these people, and all the laws had been clearly followed. Your Excellency, with respect to individual responsibility of Ms. Lisho Mangala, the defense would love to clearly state that Ms. Lisho Mangala did not have the intent in commission of the crimes. Your Excellencies, 3 key softwares that have been developed by Ms. Lisho Mangala are the ones that bring in the question of whether Ms. Lisho Mangala had the criminal intent to commit the crime. Your Excellency, while it is clear that the Adam AI software and the bad target software at some instances it could not clearly distinguish between the civilians and the military objectives, Your Excellency. This information was clearly relayed to the Republic of Kedibonyi. It was clearly brought to the table, and Mr. Shomongala did his part by clearly informing the Republic of Kedibonyi that at some point the system could have challenges. Therefore, she did whatever she could do from her end to ensure that the international humanitarian law principles were adhered to. Secondly, Your Excellency, with respect to the operation of the bad target AI software, it is clearly provided for in the factual matrix that the information that the bad target AI software collected was actually relayed first to the Asaioroma, which then later was relayed to the military bases of Kedibonyi government. And it was there that a decision was being made. So with respect to the bad target AI software, Your Excellency, it is the submission of the defense that the last target, the last resort, the last action to be taken was taken by the representatives of the Kedibonyi government, which is now the Kedibonyi military. And that's clearly provided for in fact paragraph 19 of the factual matrix. The system was effective, Your Excellency. And in fact, it was only supposed to fire after 10 seconds. And Your Excellency, we are clearly told that the military of the Kedibonyi government actually fired, the gunners used to fire prematurely in 3.5 seconds. And due to that, they used to fire prematurely and they stopped not firing. Therefore, it is the submission of the defense that the bad target AI software that was developed by Shomongala was effective, and actually the people who caused the killings is the military, the Kedibonyi military, who actually fired prematurely, unlike what was provided by the bad target AI. And lastly, Your Excellency, with respect to the Adam AI software, as it has been clearly provided for in the factual matrix, the Adam AI software used due diligence. It used to collect information about specifically the ULF fighters. And Your Excellency, it is clearly provided that it took 15 days to actually determine the correct or the right military targets in order to be able to attack those targets, Your Excellency. And therefore, it was clear to ensure that the principle of distinction been upheld, Your Excellency. Finally, with respect to the AI software, it is still the submission of the defense that indeed with the AfroOpt AI software, actually, Mr. Shomongala did not know or was not aware that it was being used to bring about confinement. With that, the defense wishes to rest their case.
Thank you very much to the Defence Counsel for their rebuttal. So we've now reached the end of the submissions from the prosecution and indeed the replies from the defence, and the judges will now go into a separate room to deliberate as to the outcome.
Court is now adjourned. Participants and spectators should wait in the courtroom as the judges go to the deliberation room to deliberate. Okay. Yes, so the judges are back into the courtroom, and at this juncture, the judges will be able to give you comments in regards to your respective submissions. Please could the teams open their videos? Okay, Tabitha, are you there? Miss Tabitha, are you there, or she's not with us?
She's having a problem with her internet.
Okay,
The
no
video.
problem then. So, Mr. President, over to you.
So I'm going to invite my co-judges to introduce themselves and provide some feedback.
Hello, everyone. I hope you're well. My name is Faith Simiu. I'm happy to be one part of your judges there. I'm currently completing a PhD in Cardiff University, focusing on health and human rights, but sometimes we do the trajectory changes, and therefore also my trajectory has changed. I was very impressed by the presentations you all made. You are all winning and strength, and you are all able to fight for your case. And I'm happy to see the presentations, which were very well done. And we're going to give you.
Thank you, Faith, for your feedback. And please, the remaining co-judge.
Okay. My name is Adeke Mary Joy. Sorry about that. My name is Deke Mary Joy. I am a lawyer from Uganda. Very passionate about international law, international criminal law, participated in a number of moots, both internationally and at a national level. So this feels like home to me, engaging with the panel. Yes, so I'll just dive right into the comments. I'll commend both teams, first of all, for your hard work and the concentration you put. I know, being a former mooter, that you have sleepless nights, and the level of research and all that you do is it takes time, it takes courage, but you know that you walk away a different person and you are set apart from your other colleagues moving forward. And this that just doesn't end at meeting stage. It takes you forward to your advocacy and yes, your future, generally your analysis of facts and your cases and your research skills, they just bloom. You become just amazing. So continue doing this. Whichever team wins, whether you win or lose, it's not a win or lose situation, it's a win and learn situation. So if you don't win, you have learned and you will carry this on for life. So prosecution, I'll commend you for your good articulation, your roadmap, specific facts, references, case law, statutory law, standing your ground on your arguments, however much the bench tried to move you left and right. And you were composed, I would say, good court language. However, I would just say there is something specific that Miss Nasija said. She said the paragraphs in the fact sheet are independent, and I don't think that is the case. This fact sheet is intertwined. It is a whole. So as you read it, much as you are reading it specifically to support your arguments on your side, you should not lie to the bench that they're independently, yes. So yes, but good job done for defense. I know a lot of network issues interrupted you, but we did not consider that. We made sure we stuck to your submissions, and we did not say, no, they had bad network. And no, the network, we understand your issue, but we went straight to arguments. I'm not considering that. I commend you for your good job. Though I think there was a challenge in specifying the facts. You're just generally referring to the fact sheet. I think you should adopt a norm of specifically tuning the judge or the bench, directing them, let them follow you. Where are you going? If you're moving from this paragraph to this paragraph, this is how it should flow. I do commend the second speaker, that is, I think, Tabitha. Yes. When asked about classification of the armed conflict, she said we concede. That is a very good approach that very many participants don't look at. Why would you waste time to go into an argument that you have accepted? Why would you go into the jurisdiction if you concede that this court has jurisdiction and you're proceeding? Why would you go into classification yet it's actually what? So that is a very good approach, and very many teams have not taken it. So I commend her for bringing that up. And even her guidance, when I gave her guidance, she took up my guidance and brought out a better argument, which shows that she was following. She was flowing with the bench, articulating their questions and what they want. Her knowledge of general basic international humanitarian law was good. So yes. However, I think the principles, I know they're intertwined. Distinction, precautionary, and proportionality, yes, they're intertwined, but you need to distinctively show which one refers to this. So yes, but good job, all of you, and I wish you good luck to the team, whichever team wins, the wins.
Thank you very much to my co-judges for providing that feedback and comments. Just really to echo my colleagues on the bench, we were really very impressed with both teams, both the prosecution and defense, and very professional, very respectful, I felt, and also was sure to rely upon the law as well as any relevant jurisprudence or case law from the different bodies. So really, very impressive, and irrespective of whichever team wins, the key really to take away from this is the experience you've gained, the skills that you've been able to hone and develop, and you can take them forward into your future careers, or even into other competitions that you might participate in. So we're really impressed, and I was especially impressed with the very high quality amongst both teams. And there wasn't really much, I would say, between them. This is a slight made our job more difficult, I think, to differentiate between the two. I'm not sure at what stage do we announce. Do we make the
before you go into the announcement, I think you should do an introduction of yourself.
Apologies. I jumped straight into the feedback element. Yes, so I'm actually Wayne Rambo, as you can see on the screen. I'm a senior tutor in the law department at the University of Manchester. I don't currently specialize in this field of this competition, although I did study it in my postgraduate studies as part of my master's. My current fields of specialization are public law, which is constitutional and administrative law, and human rights across the Council of Europe states, so to do with the European Code of Human Rights, or what's called the Strasbourg Court. But it was very interesting, even for myself, to be part of this, from a comparative perspective, looking at the African Court of Justice and Human Rights, and and it's even given me some things to go away and reflect upon, let's say.
I think that now you can proceed.
So we are delighted to announce the winners are the prosecution. And we'd like to congratulate you, and very well done. And indeed, very well done to all participants on both sides. But yes, we are delighted to announce the winner is the prosecuting team.
Okay, thank you very much, Mr. President, and the honorable judges. It has been a wonderful period, and it is impressive to have had the opportunity for you to be able to be here to impart and to be able to make it more of a learning process to the participants. All the teams, we appreciate your time and your effort. As truly has been said by one of the judges, we truly understand the position you are in. Some of us, we have been there more than 20 times in your situation, so we really understand the sleepless nights and the efforts that come with the mooting. Otherwise, as indicated, this is a learning process, and you should take it. It's a competition. Yes, we have to have a winner, but we do not have a loser. We have learners, and therefore the issues that are being discussed in the mood problem are issues that are current affairs, discussions ongoing at the UN in Geneva in terms of whether or not we should have a treaty to regulate the issue of autonomous weapons in armed conflicts. And therefore, it's a contribution that you can make from the knowledge you have acquired through the mood. So do not feel that it's a do or die situation, but rather it's a learning process. And of course, at the end of it all, we must have a team that has won, but it has nothing to do with whether you are bad or you are good. It's just about, it was, as the judges has indicated, because we were in the deliberation room, and it was a very difficult decisions to be made, but of course it had to be made because of course the moot itself. At this juncture, I will allow the president of FIS, Mr. Bukarim Aziz, to be able to close the session.
Thank you so much, Mr. Vice President. To the president of the court, Judge Wayne, thank you so much, all the way from the United Kingdom. To Judge Fates, thank you so much. To Judge Adeke, thank you so much for trying to group African scholars to make them better, to ensure that giving them everything you've had. So thank you so much. We appreciate that. To the participants you've had from Mr. Swale, that is the best advice I can also give you. So I'm adopting the advice. I can see the prosecution jumping around. This is a live session. The entire world has seen the way you jumped around. But it's okay, it's understandable. It's understandable. We understand the passion, and we congratulate you. And to Mr. Danson and his team, I appreciate the sportsmanship for congratulating them. That shows that it's not a draw die affair. It's a learning process. And for us as organizers, we have given you a platform to know one another. We've given you judges that maybe in the next 5-10 years, you may never come across them. And so if you want to do your postgraduate, for instance, your master's in the UK, you have Judge Wayne there. Judge Fates is also completing a PhD in Cardiff, the same. So, and the same thing if you want to go to East Africa, you have Judge Adeke. So this is a platform to network. It's not about winning, it's not about losing, it's an opportunity, you know, to get to know more people, because networking is key to this profession that we're in. And so please network with your colleagues, with some of these judges. If you need recommendations, if you need assistance, we are ready to provide that. That's what the competition is all about. Like Mr. Swale rightly said, this competition needs to close, and for it to close, there will be winner each round, and then we'll progress like that. And so since it's being streamed live, you can also join online and see what is happening, see the other teams, learn more from them, the mistakes the judges have pointed out, improve on them in your career. You know, you now become a better person. You participated in an international competition that has, you know, universities across Africa. That is a pride for your university to nominate you to represent it. It's also, you know, a win on its own. So see it in that light and ensure that you network. That's the most important thing. Please network, get to know some of these participants, get to know the judges. If you need help, reach out to the organizers, and we're going to do that. So finally, as I thank the judges, I also thank Mr. Swale, who is the Vice President, for presenting a balanced, you know, moot question. And we've seen that it doesn't matter which side you will have something to say. And like the Adeke said, you cannot, you know, sever the facts just because you want it to align with your arguments. It's one single fact. So thank you so much, judges, for your time, and all the best.
Thank you so much. So just for the team that is progressing, so this was the last quarterfinals. So we will email you, and of course we will send a WhatsApp message to your respective representative as far as the schedule for tomorrow's round. So all the semifinals are tomorrow, and therefore you will be able to compete against the other teams. As far as the score sheets are concerned, we will be able to send to you as soon as possible. That's it from our end, and I wish you guys the best of luck.